The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court now sitting.
Thank you. Please be seated. Good morning and welcome to the Supreme Court of Kansas. We have read the briefs of counsel and look forward to further illumination during your oral arguments this morning. Ms. Green, as Clerk of the Appellate Courts, we do the honor of calling this morning's docket. We now proceed to call the first case on this morning's docket. That is case number 103467, State of Kansas v. Jaime Rodriquez.
May it please the Court, Joanna Labastida of the Kansas Appellate Defender Office for the appellant, Mr. Jaime Rodriquez. If I may, Your Honor, I'd like to request 3 minutes for rebuttal.
3 minutes is granted.
Thank you. And unless the Court would prefer otherwise, I'd like to focus on the first issue presented in the brief and submit the remaining issues on the brief. The first issue presented is that the District Court erred in failing to give lesser-included instructions on reckless degree murder, second-degree murder, and involuntary manslaughter. Mr. Rodriquez, as far as I can tell, did not object to the lesser-included instructions not being included, and he did not request the instructions.
Doesn't it go a little beyond that? Didn't counsel say, that's right, we want all or nothing?
I had a feeling I was going to get that question right off the bat. I would argue that because that statement came so late in the proceedings after the instructions had already been given to the jury and after they came back with the question asking if they could give lessers, I think at that point, Mr. Rodriquez saying that he wanted all or nothing is a little too late to be considered invited error by this court because at the time, felony murder was not typically given lesser included instructions. The state of the law was that it was almost never given. The lesser included instructions were almost never given. For him not to object during the instructions conference was not necessarily invited error. And then by the time the jury came back with that question, he might have changed his stance and just said that he didn't want the lesser included instructions, but at that point they'd already been given. The jury instructions generally had already been given. And I would argue if it was reversed and he said he did want the instructions, I doubt that the district court would have given them at that point because it was so late in the game.
I'm not sure I'm understanding what you're suggesting. That first of all, the defendant never requested the lesser includeds. Right. And not only did he not request them, when the jury comes back with a question, he reaffirms or says for the first time on the record, yeah, I don't want, it's an all or nothing approach here, which really just confirms the fact that he never requested him in the first place for a reason, because he wants all or nothing, and he confirms that. So I guess I'm not understanding why that's not pretty conclusive as to the defendant's intent and the reasons for not requesting the instruction in the first place. Right. I understand that could be easily what you would glean from that comment, but I would argue that at that late stage, after instructions have already been given, and really lesser includeds were not really the position of the law at that point for felony murder, his saying that he doesn't want them at that point, I would argue does not rise to the level of invited error. On top of the fact that really the district court wasn't asking if he wanted them at that point, he was just saying, how should we answer this question? And since the instructions had never been given, they had to answer that there were no lesser included instructions for this case.
You're trying to get to clearly erroneous without slopping over to invited error.
What's that?
You're trying to get to clearly erroneous without edging over into invited error. Yeah, we get your drift.
Okay, thank you. And that's true. The standard for this standard of review for this case is clearly erroneous. This court reviews for clear error using an unlimited review. And if the court finds that there was error, then it must be firmly convinced that that there was a real possibility that the jury could have come back with a different verdict if the instructions had been given. And I think that...
Is that what we said in our latest cases, that firm possibility, or haven't we said firmly convinced that the jury would have reached a different result?
I believe
That's quite a difference, isn't it? That whether they would or whether we're firmly convinced there was a real possibility.
I believe the specific language is firmly convinced that the jury would have reached a different verdict had the instruction error not occurred. And I think either way, with the jury's question to the court, if they could come back with a lesser verdict, clearly.
Well, why would they have opted for the lessers in this case under these facts?
I think even with the state's medical testimony saying that the victim had suffered some sort of trauma that resulted in various different symptoms, even if you take that evidence that something must have happened to the baby, I think the jury could have found that, yes, the defendant did something, but did he do it intentionally or was it reckless? And the defendant had other theories as well. But even taking the state's evidence on its face that some sort of trauma occurred, the doctor's testimony, they can't do experiments on shaking babies, so they have to kind of guess how much trauma, how much force. And so every baby is going to be different, every situation is going to be different, and the jury could easily find that perhaps Mr. Rodriquez was just reckless in his behavior towards the child, not intentionally shaking, which is what the underlying felony was, child abuse by intentionally shaking.
There was a hung jury on the first
Yes.
trial, and the charge was the same, and the charge that went to the jury was the same.
I believe
And
so.
he went with an all or nothing approach at that trial also,
I
in
believe
terms of
you're right.
no lesser included. I just was thinking in terms of why he might have wanted to try that approach again.
Well,
sort
it's
of-
different attorneys, I think even a different expert that testified at the first trial.
Different expert for the state or different expert for the defense?
Defense, I believe. I didn't pay attention to the first trial as closely as I did the second one, obviously, but yes, he had the same approach for both trials in terms of. But on the other hand, the state of the case law at the time for felony murder was that lesser includeds were not typically given.
Counsel?
Yes.
I'm trying to understand what the evidence was to support recklessness or unintentional conduct. Was there evidence to support that?
Well, Mr. Rodriguez told the police that the baby and him were sleeping, and when he woke up, he changed the child's diaper and left the room and came back, and that's when he was not breathing. I mean, we don't know how roughly he changed the diaper. I don't know how much a 5-month-old squirms when you're trying to do that, and perhaps trying to put them back in place is reckless.
In contrast, there was evidence to support intentional conduct, correct? Because of the force that would have been required to inflict the injuries?
I'm not sure that you can say how much force is required, and if that's could be accidental, reckless, or intentional, because the doctors themselves couldn't say how much force.
Okay. So your point is not that you have a wealth of evidence to support the lessers, it's that the state's evidence is not conclusive on the greater. Is that?
And I would say that there's some evidence to support the lessers, and that's all you need to give for felony murder. Some evidence of the lesser included instructions being given to the jury.
But we don't have the typical scenario where defendants saying, "Oh, the child rolled off the bed," or the child slipped in the bathtub, or we don't have any statements that would indicate a trauma that was accidental. You're just wanting the jury to say something could have happened, maybe, kind of, sort of, while he was changing the diaper, but we don't have any testimony or any evidence to support that other than speculation. I think what Justice Byer's trying to get at is, where is the evidence of your theory?
Well, with Mr. Rodriguez not being able to say what happened traumatically to the child, but obviously something happened. So I think that the jury obviously thought something happened, and that but they didn't think it rose to the level of intentional at the time that they.
But if something happened to the baby, in which Mr. Rodriguez didn't participate, then would that bring in the reckless lessers? I mean, would he be culpable if he was in the other room and the baby injured itself?
I think that's a question for the jury. I don't know if it's reckless to leave a child unattended, but that would be something for the jury to decide. And I think the fact that they came back and asked if they could find him guilty of something lesser shows that they weren't firmly convinced that it was clearly an intentional act by him. Well, at this point, I've concluded my argument, unless the court has further questions.
Any further questions of counsel? I see none. Thank you, counsel.
Thank you.
May it please the court, Cheryl Lidke on behalf of the state. I think that last comment about clearly the jury had some question about whether this was an intentional act when they asked the question whether they could convict of any lesser included, I think it's just purely speculation. I interpreted their question to be more of a sympathetic question, as in these cases, every time we present them, juries are sympathetic with the parent because we're not claiming that the parent intended to kill the child, but certainly we were claiming that he intended the act, the abusive act, that resulted in the child's death. And I think juries are sympathetic towards defendants in those cases because they feel like their child has died, they've paid the ultimate price, so can't we convict them of something lesser than first degree? But, that's speculation on my part too. And that's my point, for her to say that the jury had some question about the intent, I think is pure speculation and improper for this court to draw any conclusions.
This case was decided the jury was instructed pre-Berry, isn't that right?
It is,
and what's your thought about if Berry was the law at the time the jury instructions were formulated and given, would it have supported a lesser?
No, and that's what I'm here
Why?
to argue today.
Why?
I think Berry leaves open the possibility.
It certainly does.
That there are some felony murder cases
right.
where you don't have to give a lesser included instruction.
And this is one?
This is absolutely one of those kinds of cases.
And why is that?
Because there is no evidence whatsoever reasonably justifying a conviction on any lesser included offense.
Why isn't there a reasonable inference to be drawn from the evidence, though?
I'm sorry?
Why isn't there room for the jury to draw a reasonable inference from the evidence that an act could have been reckless rather than intentional?
Because there was no evidence presented about a reckless act. The state's evidence presented only the theory that this was an intentional, inflicted, abusive head trauma to this child.
And that
this was not accidental. I'm sorry?
And that was based upon the degree of trauma that was required?
It was based on the degree of trauma, inconsistent with the history that was given by the parent. But basically, yes, the degree of trauma that was noticed during the examination of this child at the hospital and then upon the autopsy as well.
And so would you disagree with counsel's statement that there was a window of open there, that just even a rambunctious child who was upset while you were changing the diaper, that
there could have been enough shaking at that level to have caused the brain injury?
If there had been evidence of that presented to the jury, then maybe the judge should have given a lesser included instruction of some sort of a reckless homicide. But there wasn't any evidence presented by the state or the defendant that this baby was mishandled during the changing of a diaper. I mean, there was absolutely not a shred of that evidence. Their defense was not, I was reckless and I accidentally could have done this. Their defense was, he died of whooping cough. There was no injury to this child, according to him, either accidentally or intentionally.
What about the fact, just the simple fact that the jury must have been concerned, at least, when they came back and said, can we convict him of a lesser charge?
Well, that was...
And we also have an acquittal here on the first trial, and I understand the jury didn't realize that, but... I'm sorry, not an acquittal, I apologize, a hung jury. But it just seems to me that there are some circumstances here that show that the jury was struggling.
I think
in this case and in the previous case, and there's also some facts here that are troublesome that the jury, I think, heard about this child's illnesses in the days preceding. He was a premature infant, and isn't there some information in the record that he had swollen up so much just 2 days before when he received the steroids that he wasn't even recognizable? Wasn't there some information about his physical condition, or did I just see that in the record?
No, I don't recall any evidence presented that he had swelled up so much that he was unrecognizable.
Was there evidence that he was having some pretty severe physical difficulties just 2 days before this incident?
The state's evidence, which included evidence of his medical history, he had gone in for some wheezing, but not... It wasn't given to him because of some sort of swelling problem.
He received steroids just 2 days before?
Correct.
Okay.
Because he was having a breathing problem.
And there wasn't any testimony from any expert that steroids can cause swelling and swelling of the brain or anything like
Correct.
that? So if the jury was concerned with that, it would have been their own concern.
Well, I don't know, but what your first question to me was, doesn't the question from the jury or the fact that we had a hung jury the first time indicate their concern about intent? And I say that's pure speculation. In my experience in doing these kind of cases when you have a baby that has died and you've charged the parent with not intentionally killing that child, but with doing some sort of an intentional act that was an inherently dangerous felony that resulted in that death, juries are sympathetic towards defendants. They feel like they've paid the ultimate price. Their child is dead. And so isn't there something in between first degree and acquittal that we can convict them on?
That's the purpose of an all-or-nothing defense, is it not?
Probably.
The defendant wants to give the jury too hard a choice.
Right.
So that they opt for acquittal.
Right. But getting back to the question about the evidence in this case, there was no evidence that the defendant accidentally or recklessly cared for this baby. I believe his statements to the initial responders came in through the state's case, and that was his history provided to the doctors, even at the hospital, was that this baby was just on the bed and suddenly became ill. He had no explanation for it. There was no evidence that he was improperly handling the baby or recklessly handling the baby during routine care. There was no evidence that he was just exerting more force than necessary when he changed the diaper. There was no evidence that he noticed that the baby was getting sick and then waited too long to call 911. His story was basically, this was a well child and all of a sudden became sick, and I called 911 when he became unresponsive.
Counsel?
Yes.
Can I just go back to the evidence supporting your case for a moment? The evidence of an intentional act that inflicted the injury. I want to just understand exactly what it is your experts said. They talked about the trauma,
right,
and how severe it was. Did they actually go to intentional? Or did
yes.
Okay. They used the word intentional?
Every one of them said that this was intentionally inflicted abusive head trauma.
Intentionally inflicted.
Yes.
Okay. That's what I was getting at, rather than just severe.
That it required some sort of a violent shake or shaking. It could have just been one shake. It could have been a shake where he was just thrown onto the bed even. or it could have been multiple shakes. They couldn't. That was the part that they were vague about. They couldn't do tests to determine how many shakes, or whether he was just thrown onto the bed or hit up against something. But all of them, the emergency room doctors that first saw him, the child abuse experts at Children's Mercy who examined him, the pediatric ophthalmologist who looked into his eyes, and then the pathologist who did his autopsy, all conclusively said this was intentionally inflicted abusive head trauma. Not one of them equivocated on that.
Thank you.
And that's why I think this is a case, even if Barry had been decided before this trial, would say no lesser includeds were appropriate in this case.
Let me take you back to the place where the question came from the jury.
Okay?
Can we convict of something less? At that point, was it too late to give lesser included offense instructions?
Well, I think a judge has the ability to always correct the instructions, so probably he could have, if he felt like he'd made a mistake in the instructions and that they were being misled by his original set. He probably could have, but I don't think it was required in this, under the facts in this case.
Could have at that time duly instructed them on lesser included offense?
I'm sorry? Could he what?
Could have at that time newly instructed them on lesser included offense instructions? Is that what you're saying?
I think I really haven't thought it through and analyzed that, but my recollection is that a judge has the authority to correct himself in his instructions, and if he's forgotten to give a lesser included that he now determines that he should have given, then I believe that he has the authority to re-instruct the jury and to tell them to begin their deliberations again.
That's essentially what happens when an instruction is clarified, for example.
Right.
It's modified.
So I'm not sure, Justice Ness. I didn't look up case law or the statutes that apply to that, but my gut tells me that a judge has that authority to do that if he believes he has incorrectly instructed the jury from the beginning.
And following that structure of analysis, is it your argument that when this question came back from the jury and then the defendant said basically all or nothing, the court had performed this mental calculus and said, well, I guess there's no point in my correcting myself and making a new instruction on lesser included because the defendant has now told me he doesn't want to do that? Is that what you're saying?
Yeah, then I think you get more to an invited error analysis. I think it would have been stronger for me to argue that it was invited error if, in the very beginning, the defendant had said, I don't want any other lesser included instructions.
The defendant did approve the proposed instructions that left it out, though, right?
Correct. That's correct. I wanted to argue issue number 4, and I see I do have just a little bit of time if there's no more questions on issue number 1. Issue number 4 dealt with the instruction on the underlying felony of child abuse and whether that automatically told the jury that any kind of shaking constitutes great bodily harm. We don't believe that that's what the instruction told the jury. It was straight from Pick. The judge in this case did not modify the Pick instruction in any way, like they did in the cases cited by the defendant in their brief. The judge instructed the jury that they had to find that the defendant intentionally shook the child, which resulted in great bodily harm to the child. The judge never said to them that if you find that the defendant shook the child, that automatically constitutes great bodily harm. And clearly, the evidence in this case proved much more than just a shaking. It did prove an intentional shaking that resulted in great bodily harm. And there was overwhelming evidence of the bleeding and swelling to the brain, the retinal hemorrhages, which eventually killed this child. So there is no possibility that this instruction misled the jury or that it was incorrect in its statement of the law. It was not clearly erroneous. That's all I have unless there are questions from the court.
Any questions of counsel? Thank you, counsel.
Thank you.
Just to quickly answer Justice Moritz's question about the child being unrecognizable swelling, that's volume 15, page 470.
2 days before.
Right.
2 days before he was brought into the emergency room, and the jury heard that, right?
Yes.
With pretty severe swelling
Correct.
and an allergic reaction, and he was given steroids.
That's correct.
And he was 5 months old and a premature child.
And the defense expert also explained that sometimes people that are given epinephrine shots have swelling of the brain as well. So I could see the jury thinking just a culmination of events resulted in this child's death, not necessarily intentional shaking.
Now, there was contrary evidence to that expert's testimony. I think there were other experts, or at least one, that said that an epinephrine shot would not have caused, or did not believe that that shot would have caused that kind of swelling to the brain. But
I don't remember that off the top of my head, but I take your word for that. But that just shows that there was some evidence for either side.
right, thanks.
Anything further, counsel?
I do
But that
not.
evidence wouldn't discount any intentional act. I mean, that's offering a different explanation as to the cause of death, isn't it?
Well, with the swelling of the brain, that was a large part of the trauma that the child had. His injuries that resulted, and that's a lot of what the doctors were saying showed that there was some sort of shaking. Was that his brain was swelling, and his skull.
So did you offer an explanation, or did the defendant offer an explanation at trial that perhaps there was some other conduct that the child was susceptible because the brain was already in a state where it was more vulnerable? Was that ever offered as an explanation?
The defense expert had several explanations for various symptoms that the child had. Potentially that he was diabetic, that he was ill, and that the symptoms of those.
But
things might be
those
different.
conditions weren't as a result of the handling of the child.
Yes,
Okay.
you're right. Other than not recognizing those symptoms and the resultant,
Understand,
yes.
right.
So handling the child and that you're not calling the doctor soon enough.
Any more questions of counsel? I see none. Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement.